name is Schyler Church. I am a California real estate broker as well as a member of the education department here at Accredited Real Estate Schools. We offer those course requirements to be eligible to take the state exam in California for that real estate salesperson or broker's test, but we also offer a lot of different options for state exam preparation. One of the things we offer are practice questions. So we're going to do a few questions today, go through them, and hopefully you learn a little something from these. And remember, if you do like our practice questions, we do have a database of over 3,600 questions for $50 1-year access. And I have the link below if you'd like to order, as well as if you need the courses or other exam prep. Feel free to reach out to us. Check out our website. We are here to help you on this licensing journey. So let's start with question number 1. An IRS 1031 exchange would not be allowed if A, the properties exchanged are both vacant land, B, one property is in Arizona and one is in California, C, one property is a leasehold over 30 years, D, the properties are not of a like kind. Well, what do we know about an IRS 1031 exchange? Remember, that is the delayed exchange. So you, as a property owner, can sell a property and then you have 180 days with strict procedures and parameters to follow. You could basically buy another property, but it has to be of greater value and you incur the same level of debt. The big thing, though, is with any real estate exchange, when you're postponing the payment of taxes, well, it has to be any real estate for any real estate. So they have to be of like kind. That is the big thing when it comes to an exchange. They have to be of like kind. So it could be any real estate for any real estate, whether that be a single family home to a commercial property, vice versa, vacant land to an industrial property, or even a leasehold estate. Any of those are okay as long as it's any real estate for any real estate. It has to be of like kind, and they have to follow prescribed procedures, of course. So if the properties are both vacant land, that's okay as long as they are of the same, they incur the same level of debt, and they it's of greater value. So then that would be okay. So A is not correct. One property is in Arizona, one in California. That is totally okay. It doesn't matter as long as it's of like kind. And one property is a leasehold over 30 years. That's okay. That is still real estate. Now, D, the properties are not of a like kind. That would be the correct answer because they have to be of a like kind for an exchange. So they have to be of like kind. Any real estate for any real estate. 2, compliance with the agency relationship law enacted as part of the Civil Code would be required on which of the following transactions? A single-family residence offered for sale by owner. B, a foreclosure sale by a trustee under provisions of a deed of trust. C, transfer of the husband's interest to his wife in a divorce proceeding. D, a broker who negotiates a lease for a period of longer than 1 year on one half of a duplex. So when would you have to follow agency law? Well, first off, there has to be an agency relationship created, right? So let's see here. A, if it's a single family home that is a FSBO for sale by owner, well, there's no agent involved in that. So they would not have to abide by agency relationship law because there is no agent involved. Foreclosure sale by a trustee under provisions of a deed of trust. So it's been foreclosed. That's by that trustee. So that's a trustee sale. There's no agent involved in this to this point, at least. Maybe when it becomes an REO, it could be, but at this point, no agent involved. There's no agency relationship, so you wouldn't have to follow any agency relationship laws. Transfer of the husband's interest to his wife in a divorce proceeding. So that husband is giving his transfer to the wife. No agent involved in that. So you would not have to abide by that. But D, this is the correct answer because a broker who negotiates a lease for a period of longer than 1 year on one half of a duplex. First off, this is the only answer option where an agent is involved. So we know, okay, that's probably the best answer. But also because it is a lease of over a year, well, then you also have to have that agency relationship a law has been followed properly. And the disclosure would have to also be provided. So D is the correct answer. 3, a licensee has an office with 18 mobile homes on display. How is he able to sell them? A, he has a mobile home dealer's license. B, he is licensed by the DRE. C, he cannot legally sell them. D, none of the above are correct. Well, what do we know about mobile homes, mobile or manufactured homes? The big thing is with a real estate license, if it is personal property, so where you're just selling the structure, it's not real property, well, we can only sell it if it's been registered. We can only ever sell them if they've been registered with the California Housing and Community Development. That is the only time we can ever sell a personal property, mobile or manufactured home. If it is not being sold as real property, so with a deed, and it's not been registered, then we would have to have a mobile home dealer's license. So in this case, we do not know if it's registered. Because of that, we would have to have a mobile home dealer's license. I actually had a question very similar to this on my broker's exam. So that's why very important to make sure you understand when you can sell a mobile or manufactured home. Remember, we can sell it if it's being sold as real property, so being sold with the land, or if it has been registered. Those are the key words there. If not, we'd have to have a mobile home dealer's license. 4, a building that is an improper improvement to its site is an example of A, economic obsolescence, B, physical deterioration, C, curable economic obsolescence, and D, incurable functional obsolescence. So let's dissect the question here as always. So a building, this structure that is improper, so this improvement does not make sense on its land. What is this an example of? So the structure that doesn't make sense on the land, that's basically what it's saying. What's that an example? Well, economic obsolescence, remember, that is loss in value due to external causes. So that wouldn't be based on how it's placed on the property. That would be internal types of depreciation. Physical deterioration, remember, this is loss in value due to running the wear and tear of an improvement. So remember, where it's located on the property isn't wear and tear. That's more of a design, so where it's placed on it, it's a little bit of it's functionally weird. So the styling issue, design issue. Curable economic obsolescence. No, we don't really care if it's curable or incurable, because remember, economic is external, so that would not be correct. But D, incurable functional obsolescence. Remember, functional obsolescence is loss in value due to something that is internal of the property lines. So within the property lines, usually due to styling, design issues. So if the building is located kind of funky on the property, on the land, that would be an example of functional obsolescence. And in this case, incurable functional obsolescence. Now, it could be curable if you were to move the building, change it, but that's just a whole other debacle to get into. So incurable functional obsolescence would be the correct answer. 5, a broker agent can pay a finder's fee to an unlicensed individual. A, provided the finder's fee is no more than $100. B, provided the finder's fee is not more than $250. C, only for introducing a client to the broker agent. D, never. What do we know about finder's fees? This is when the broker is able to pay a non-licensed individual for introducing someone to them. Only ever for introducing, because if somebody does not have a license, they can never solicit business on behalf of a licensee. But merely making an introduction, that is okay for an unlicensed individual to do. And if so, they could be paid a finder's fee from the broker for making that introduction. There is no cap on the amount of it, but it has to only be for introducing the client. So C, only for introducing a client to the broker agent. Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.